Hello, and welcome to another episode of Ask Two Lawyers. I'm Keith Davidson,
I'm Stewart Albertson.
and we want to thank you for joining us this Friday afternoon to take a Q&A day. So we've got some questions that have been coming in on our different videos, people posing some different questions, and we thought maybe we'd answer a few.
And we're going to try to sound as confident as we can in our answers.
Yeah, that's right. Just the advice is worth what you paid for it. So you're getting free advice, that's what it's worth. But we'll kind of see where it goes. So producer Eric, if you could kindly give us a few questions. How are you doing today, producer Eric?
I'm doing great. It's Friday. I can't
Good.
complain. I'm always happy to see you guys. So, and get on a pod like this. So, yeah, we'll start off. This is a question that was left on our YouTube this week. Someone says, from your experience in such cases and trials, is it out of the ordinary for the plaintiff's attorney to withdraw as counsel 4 years into litigation / approaching trial? They also went on to say, is it also unusual for the case to remain pending for the next 2 to 3 years in the court docket? Kind of two separate questions, but you guys can expound on that.
So it's already, my understanding from the question is it's been in the court system 4 years, and they're saying, is it normal for it to last another 2 to 3 years after that?
I think the genesis of the question was, is it normal for a lawyer to withdraw from representation after 4 years on the eve of trial? That's what I heard.
Right.
And I'll take a crack at that. And it's unusual because it doesn't happen that often. But when it does, it's tragic. Usually it's tragic, probably for the firm in some respects. It's certainly tragic for the client, but there's been something that's happened with the lawyer and the client and their relationship that requires that withdrawal to take place. And that can be many things. It could be something like a conflict of interest arises between two beneficiaries that are represented by the same law firm. The lawyer doesn't have a lot of room to work there, and so may have to withdraw. But more often than not, it has some personal relationship that has been degraded between the lawyer and the client, because these are stressful cases. And when things don't go as we want them to, and we're not in charge of judges, we wish we were, we're not in charge of the rulings. And so there's cases where the rulings go in our favor time and time again through a case. That's much easier for a client to sit through than if there is a loss of a demur, a loss of a motion to strike, a loss of a motion for summary judgment, or whatever the case may be. Now the client's getting more frustrated, and the lawyer's trying to tap dance and explain what's happening. Keeping in mind that lawyers are not in charge of what judges do, and every judge is different. Some judges get excited about one set of facts, and maybe they ignore another set of facts, and you got another judge that will do the exact opposite. So ultimately, it's not normal. It doesn't happen often, and when it does, it's tragic. But I will point out to the listeners, and if the person who posted the question is listening, most judges aren't going to allow a lawyer to withdraw on the eve of trial. And maybe, Keith, I don't know if you would be willing to take a shot at why is that?
Yeah, and in order to withdraw from a litigated case in California, you have to be removed as the attorney of record. So just because the lawyer wants out doesn't mean they're automatically out. And there's two ways that a lawyer can be removed as attorney of record. One is if a client voluntarily signs a substitution of attorney, and the client can substitute themselves in as their own attorney, or they can sub in a new attorney if they want to go hire a new attorney. And then if that doesn't happen, then the lawyer has a right to file a motion to be relieved as counsel. And that's a little bit more traumatic, I think, for the client to have a motion filed by the lawyer saying, I don't want out of this, I want out of this case. And the reason why a judge may not let a lawyer out is if it's too close to trial. The court has the discretion to say, well, I think that this will be too damaging to the case, and the court is in charge of management of the cases. And I think it'll be too damaging to the client, so I'm going to force you, lawyer, to stay in here. And that means the lawyer has to keep going and go through trial. Most judges are going to err on the side of letting the lawyer out if that's what the lawyer wants, because clearly there's a breakdown in the attorney-client relationship if the lawyer is saying, I want out. I mean, something has gone terribly wrong if the lawyer says, I quit. And it could be a difference of opinion on how to handle the case. It could be a difference of opinion about witnesses. A lot of times, the client just can't pay anymore, and so the lawyer doesn't want to keep going without being paid. Any number of issues that come up. I'll tell you the conflict of interest one, though, that you pointed out, that's really important. And I think people don't understand it, because you and your brother or sister or whoever it is can hire the same lawyer, and everything can be hunky-dory throughout 4 years of litigation. And then at the last minute, if one client says, I want to settle and take some amount, and the other client says, I'm not settling no matter what, that's what we call an active conflict. And a lawyer cannot represent two people who are in active conflict with each other. And so they just have to bow out of the case. And, it's too bad, but I don't think people fully appreciate the dangers that await them. When multiple people hire a lawyer, you really got to get along with the person that you're going in on the same lawyer with, and understand that you're going to have to keep getting along, not just now, but in the future. You're going to have to compromise, because if you don't, you might be without your lawyer, because the lawyer may have no choice but to bow out. And that's under our ethical rules. We don't have a discretion one way or the other. We can't do it.
Right. And in addition to that, not just getting along with the other co-litigant you're litigating the case with, what happens when one of the co-litigants has a right to 20% and the other one has a right to 80%? Well, now we have differing interests. The person that wants 20%, they probably are going to want their full 20%,
Right.
and not take much of a haircut. Where the person that's going to get 80%, well, in negotiations, they might be willing to give up some of that to resolve the case. Well, now it's not that they're not getting along. They just see the case differently now. And so there is a case where a lawyer may have to withdraw and hopefully, under a friendly situation, get another lawyer to come into the case to represent the 20% or the 80% lawyer or a client, with the idea that you could still represent one of them going forward. Or in bad cases, you got to withdraw from both of them as a lawyer, just because that's what the ethical rules require.
Yeah. I mean, there's all sorts of different twists and turns. So you really got to think about that. And we think about that when we take on representation of multiple clients. We obviously disclose it. We talk to them about it, and we think about it ourselves. Do we really want to go down this road? How well are these people getting along? I will say, though, that it's not uncommon for court cases to last a long time, longer than people think. And so if a case lasting 4 years, especially if it's a trust contest case or who knows what it is, it's not entirely uncommon for a case to last 4 years. We certainly try to get our cases moving faster than that, but we're not in control of it. We're only in control of a part of it. The opposing attorney has control. The court system has control. The backup in the courts have control. So you can't necessarily, do that. Although in California, we do have the 5-year rule. And so if your case doesn't go to trial within 5 years, technically, it can be dismissed. There are exceptions under the probate code and, in the probate system. And we certainly don't like to see cases drag out 4 or 5 years, but I've seen them do it. And I've certainly have had cases that have gone on way longer than I would have liked in our court system. And it's just because we don't have enough judges. I mean, our court systems, the people in the court system do a tremendous work for the amount of work they do. But you and I were just at the Hawaii Tax Institute, and they were giving a report on the, status of the courts in Los Angeles. And each judge apparently has 1,000 cases, they said. 1,000 cases per judge. And that has gone up like threefold from where it was just 4 or 5 years ago. And so the amount of work that the court system has explains why they're so backed up. So I usually tell people, look, have you ever been to the DMV? Well, the court system's kind of the world's worst DMV because it has the longest line you can imagine. You just don't see it because you're not waiting outside the court. But it can be pretty backed up.
So with that said, Eric, I do see that somebody named Sharon has posted something, and the only reason I want you to bring this to our attention is because that's my mom's name. So it's got to be a good one.
Oh, wow. Yeah, I want to bring this up. This seems like a really great question, so I want to get to it now. I'll put it on screen as well. But Sharon says, what do I do when the trustee gives 3 different versions of the formal accounting without any documents, and each are less than the one prior? Then leaves out the additional sale of the real property.
Yeah. You go to court. You find yourself a lawyer, you go to court. That's a problem. That's a huge red flag. So just because a trustee gives you an accounting doesn't mean it's right and doesn't mean you should trust it. You're entitled to the backup information. And if they won't give it to you, then that's when you file your objections in court. You file a petition and you start have your lawyer issue subpoenas to get the information directly from the banks, the brokerage accounts. We've subpoenaed escrow companies before to find out what's happened on the sale of real property. You really got to do your homework and the legwork to see what's going on behind this accounting. And then when you do that, you can bring your surcharge claims against the trustee and hold them liable for what they're doing. It's not easy. It is a fair amount of work to hold the trustee's feet to the fire, but you got to do it. I mean, if I was dealing with a trustee who was doing what you described, I wouldn't want them to just get away with it, because it's not a good story. What do you think, Stuart?
The only thing I would say is how much money is at stake. I mean, if there's, if it's $100,000 total estate and trust, I don't know. You have to weigh the cost benefit analysis of whether it's worth getting a lawyer involved and paying the lawyer's fees, paying the court fees to have that. But if this is California, the sale of any modest real property is going to be $500,000, $1 million, somewhere in there. It sounds like this is the kind of case that Sharon would probably want to seek the advice of a lawyer and see what her rights are, and potentially petition the court and seek redress against the trustee.
Yeah, right. And that is a good point. I mean, if the issue is, there's a missing $10,000 and you get 1/4 of it, it may not be worth suing over, but sometimes you don't know. I mean, that's the problem with a situation like this, is you don't know what's going on. You don't know if everything's being done appropriately or if they're stealing money. Who knows? So sometimes you have to pay an attorney just to get in the know and, get out of the dark.
Well, good luck with that, Sharon. We hope that you get, at least we hope we answered your question, and we hope that you find somebody that can give you some comfort in which direction to move forward with.
Yeah, absolutely. And we got another question this week, kind of along, talking about trust terms and trustee issues. Someone wrote in and said, in order for a trustee to withhold distribution, doesn't the trust document distribution language have to be stated directed or discretionary? For example, what if the trust states the trustees shall distribute per beneficiary's direction?
That's not clear to me. I think I get the ballpark of that question, and it really comes down to, when is a trustee required to distribute trust assets to a trust beneficiary? And this happens all the time in our practice. There are two types of distributions, two basic types of distributions. One is what we call an outright distribution, and the other is what we call a discretionary distribution, where the power is left to the trustee, and they're usually given some type of a HEM standard, which for health, education, maintenance, and support, whatever that means, they can make some distributions on that. But I think this goes more towards the outright distribution question. And unfortunately, we're seeing trustees regularly choosing not to make these distributions, because the fear that they have and the fear that their lawyers have is that if I make this distribution, number one, I'm just arming the beneficiary with money so they can go out and hire a lawyer and come sue me. So what does the trustee do? It says, I tell you what, I want you to sign off a waiver, a general release against me, and then I'll make the distribution. Well, the probate code doesn't allow for that. And so then the final thing that really smart lawyers do, that are good trust administrators, they'll send you an informal accounting, which isn't that expensive to put together, an informal accounting. And they'll tell you, here's the accounting. If you approve it, we'll make a distribution to you. But if you don't approve it, then we're going to file it with the court, and the court's, the hearing on that, it's going to be 120 days or 6 months from now. And then if you choose to object to it, it's even going to be dragged out farther. So that's the way really good trust administration counsel do it. But you shouldn't be, as a trustee, withholding distributions that are rightfully to go to the trust beneficiaries. But we see trustees do it all the time.
Yeah, bad trustees will withhold distributions. It's insane, especially when the trust document says you can't do it. I do find it annoying when, and you're right, a good trust counsel will say either approve my accounting or I'm going to go to court and have the court approve it. And they have the right to do that. I find that approach frustrating, because it's like, gosh, now you have to wait 4 to 6 months to get that court approval, or maybe even on a good day, maybe it's 3 months, but it does take time and money. I think a little bit better approach, if you really want to keep the beneficiaries happy, is make a preliminary distribution and then ask them to approve the accounting, and if not, go to court. And a lot of trustees don't want to do that. They'll withhold the entire distribution. And I think the problem with that is you're spreading ill will right from the beginning. Whereas if you give some distributions out to people, everybody kind of calms down. So as soon as you make that preliminary distribution, it kind of it's a release valve. People aren't so up in arms, and then you can work through the next issue. But I can't argue with the fact that a trustee has the discretion to do it that way. It's just not the way that I think is necessarily the best in terms of working with the beneficiaries and keeping everybody just calm. So,
Well, and we've seen, multiple times where an older brother or an older sister feels very paternalistic towards
Right.
the younger siblings. And the younger siblings, maybe one of them had a drug problem at some time or wasn't good with money, was a spendthrift. They just spent all their money every time they got their hands on it. And so they're being paternalistic and saying, no, I'm not going to give this to you because I care for you. And of course, that's not the trustee's job on an outright distribution trust. They've got to make the distribution. It's more complicated, though, where you get the discretionary standard for the trustee, and that is the trustee's not required to make distributions, but can in their discretion.
if they want to.
That's a whole nother subset of analysis. But the outright distribution, that should be happening.
Yeah. And I think the problem is so many people who haven't been trustee before, they'll step into the office and start acting as trustee. And in their mind, they'll think, oh, I'm the same as mom and dad.
Right.
I can do what mom and dad did. I can do whatever I want.
Or mom and dad told me what they wanted me to do.
Right. I'm in charge.
Yeah.
And that's not the way it works. You can't do what mom and dad did. They were the settlors. They could do anything they wanted. You cannot.
Right.
And now you have to follow the trust terms as written, not with whatever you thought mom and dad told you. So if you're a trustee for the first time, you have never done it before, get yourself a lawyer.
Yep.
Listen to the lawyer and learn your trustee duties, because you're going to be held liable to those duties if you don't follow them. And I think that's a big mistake that a lot of people make when they try to act as trustee and they've never done it before and they're not aware of the concepts and the obligations that they're taking on.
Yeah, you said to get a lawyer, and I think that you're 60% right there.
Okay.
I think you should get a qualified
Yes.
lawyer. And the only reason
Right.
I say that is
Right.
because we end up going against it. There's nothing wrong with personal injury lawyers. There's nothing wrong with insurance defense lawyers. Well, maybe there's something a little wrong with
Yeah.
insurance defense lawyers.
Right.
They don't
That's
have
another
soul.
episode.
They don't have a soul.
That's
Other than that, but you have to get somebody that knows what they're doing. And so, we get people that call us all the time and say, hey, how do I find a lawyer? Or if we can't take their case, they say, how do I find a lawyer? I mean, there's some very simple Google searches. You can do Chat GPT. There's Perplexity, another AI platform. There's all kinds of places you can go to. But ultimately, what you're looking for in California and maybe other states as well is you're looking for somebody that handles trust contests or will contests or probate litigation or estate litigation. And so if you search for lawyers that handle that, Google algorithm is going to give you, a hit of probably the people that do it best. And then just call them up, interview them. Not every lawyer fits with every client and vice versa, but call 3 or 4, 5, 6, however many people you want to, and interview with them. And hopefully that will put you in a place where you get the right lawyer to help you as you navigate a very difficult area under California law.
Yeah, no, I appreciate you said that I only got 60%. After you said that, it's like I might have only got 10% because finding the right lawyer is probably 90% of the problem. And it is very important. And you need a lawyer who knows what they're doing.
Yeah, remember Keith and I went against a lawyer a couple of years ago that had been a police officer for about 20 years. And, he had an attitude of a police officer with 20 years. And he hadn't even been practicing a year yet, I don't think, which, again, we're generally very kind to younger lawyers.
Yeah, that's fine. Yeah, we all have to learn.
But this lawyer was not kind, and he was giving us a tough time. But he ultimately was going to name himself as the expert in the case. He's the lawyer. He's the expert.
Right.
And, it's just when you go against, I used to have a full head of hair.
Yeah.
I lost some hair in that case because I'm just sitting there trying to explain to the lawyer something that's good for his client, something that's good for our client, but he thinks I'm being nefarious. He thinks that I'm
Right.
trying to take advantage of him somehow, some way. Whereas if you would have searched for one of those people on the first or second Google page and found somebody that actually says that they specialize in this area, chances are we wouldn't have to go through all those explanations as to why this is good to resolve the case this way.
That's a really good point, because when you have a lawyer who doesn't know what they're doing, they don't know what to say yes to. And so they say no to everything. Well, if your lawyer is saying no to everything, he or she is making the case 5 times more expensive. It's going to last 5 times longer, because there are things that you can say yes to, and you come to an agreement or stipulation, you move them to the side, and now let's focus on what really matters. And it's so frustrating when we come up against people who just don't know this area of the law, but they want to practice in this area anyway. And they don't. I guess the problem that I have with it is that's fine, but sit down, study it, learn it, improve your skills, like do something to understand what you're doing. And instead, they don't do that, and they just say no to everything. And it makes the case so much harder for everybody involved, including their own client. But they don't always see that, unfortunately.
Eric, it looks like we're getting some more questions.
Yeah, we'll get to a couple of these questions. I'm going to mix these up in order just because for time's sake and what the answers may be. Someone wrote in, they said, our attorney requested entire file from a state attorney. Trustee has not given us any information. Death occurred over 6 months ago. How many days do they have to respond to requested files?
It's not clear to me who the parties are here. I'm guessing that this individual's attorney represents them as a beneficiary, and they've asked the trustee council for information. Is that the way you're reading that, Keith?
Yeah, and they may have also asked for information from the estate attorney. And so look, maybe they're asking for both. The estate attorney and the trustee has not given us any information either.
So the estate attorney doesn't have to give trust beneficiaries anything. The estate attorney is not required to give trust beneficiaries anything other than there are two things that an estate attorney must do if they're in receipt of the original documents, or even if they're not in receipt of the original documents, but if they have the original will. First thing is, under Probate Code 16061.7, they must provide a copy of the most operative instrument for the trust, and that's important, the most operative instrument for the trust within 60 days of the decedent's death, or within 60 days of a trust becoming irrevocable due to incapacity or something like that.
Right.
So ultimately, let's just say when the person dies, when 60 days later, you as a beneficiary or an heir should be receiving what we call statutory notice, which puts you on notice that you have 120 days within which to challenge that trust. And if they've included a copy of that trust, you truly have 120 days. If they haven't included a copy of that most recent trust, then you can ask for it and they should give it to you.
And they have 60 days to send that to you after the date of death.
That's correct. They have 60 days. So it gives them a little time and a little room. The other one has to do with the will. And in California, we have mostly pour over wills. Those are due to be lodged in the county probate court where the decedent died within 30 days of their death. And there's maybe 1 out of 100 lawyers that do this.
Right.
So generally, when we ask for a copy of the trust, we'll just ask for a copy of the will. If they give us grievance there, we'll say, but you're supposed to have lodged this with the county court in any event.
Right.
And then I'll say one more thing, Keith, and then you can correct all the things that I've said here. And that is, if you're asking for the file, the estate planning lawyer's file, the only way you're truly going to get that is after you file some type of pleading in the probate court. And then you're going to get it by way of a subpoena. And some people say, but wait, what about the attorney-client privilege? What about the attorney-client privilege between the decedent and the estate planning lawyer when they drafted their estate plan? And California, in its infinite wisdom in regulating just about everything that we do, they have made these provisions in the evidence code that allow us, the living heirs and beneficiaries of a decedent, to get to their intent. And that means including all their estate planning documents and notes that the lawyer has, if the lawyer is willing to provide them, so that we can kind of figure out after the fact, what is it they intended to do with this estate plan.
Yeah, and the rub here is, you're right that under the probate code, the estate planning attorney and the trustee only have to provide the operative trust documents, which means that they don't have to provide prior amendments, which just frustrates the heck out of me, because of course, the beneficiaries want to see prior amendments, especially if you've been disinherited. Was I in there before? And so you'll request it and they'll say, well, under the probate code, I don't have to give it to you. But if you file a lawsuit, a trust contest lawsuit, and you serve a subpoena and document demands,
guess what you get?
You're going to get it. And so under the CCP, the Code of Civil Procedure, you can get that information, but you can only do it after you have a lawsuit filed. Whereas under the probate code, you're supposed to be given the operative trust documents, which does not include the prior amendments. So it's really kind of a catch-22. And so the answer to the question is, what do I do if the estate planning attorney or the trustee is not giving me information? You file a lawsuit, and then you've got subpoena power. You can do document demands and all the things that go along with it.
So that question was from C. Kearney, and I hope we did answer your question. I don't think either one of us were 100% clear on what you were asking, but I think we probably got to it.
And thank you for posing the question.
Yeah, appreciate that.
And here's another question, maybe applies to you too, maybe it doesn't. I think some things are not like the TV shows and movies when it comes to court and judge and everything, but maybe they are. But Jennifer writes in, she says, what is your most outrageous story about a judge completely refusing to follow the law? And what did you do about it?
So
wait, this starts with the premise of judges follow the law, but okay, go ahead.
of course they do.
Yeah, of course they do.
What are you talking about? So first of all, Keith and I think that every judge in California that we appear in front of is fantastic.
Absolutely.
Wonderful judges. But Jennifer, in answer to your question, if it's okay if I take a step.
Yeah, go ahead.
Keith and I were in front of a judge that we actually admired quite greatly in Santa Clara County a couple of years ago. And the opposing sides had triggered the no contest clause in a trust. And it was clear that they had triggered the no contest clause in the trust, and there was no probable cause exception. And in other words, the judge couldn't let them off from triggering this no contest clause under this strand or brand or string
under this element of the no contest
branch
clause.
of the no
Yeah,
contest
there you
clause. And so we made a very compelling argument to a judge, and we were right on the law. And the judge declined to agree with us and simply said, no, I do find that they did trigger the no contest clause, but I'm not going to hold it against them. So we appealed that. That's what you do when you disagree with a judge. It's done respectfully. You're not doing it as you wouldn't say to a judge after the judge rules, well, I'm going to appeal your ruling, judge. That's a no-no. We have to give the judge the court the respect that it's due. And so we go through the procedures that are allowed to challenge a court's ruling, and that is to appeal it. And we did win that, right?
Yeah, we won on appeal.
But it took like 3 years to get
because it takes forever to go through the appeal process.
And so we're explaining to our client who won, and now she's saying, I really don't feel like I won because I've just been put through another 3 years of litigation. But she did win, and the appellate court did call it our direction. And again, we were very respectful in the challenge that we did to this judge because we admired this judge. We thought this was actually a very good judge. She's now a mediator up in San Jose. That was my story. And maybe you have one you can share.
Well, I don't know if that, I think that's the most clear-cut example of where somebody triggered the no contest clause by filing a creditor's claim. There's no probable cause for that. They're dead to rights, and yet the judge did not want to disinherit them. I don't know if it's the most outrageous, but certainly is the most clear-cut example of a judge just choosing not to do that, and then you appeal and we win. But it does happen, and I think people don't realize, especially in probate court, the full discretion that judges have. And so probate court is a court of equity. And what that means is the judge decides. On almost all of the issues in probate court, the judge decides. It's judge discretion. That's a little different than when you're talking about rights at law, like a civil contract or a tort, where there's legal procedures and legal rules that have to be followed. In equity, the judge can decide. They can just, say, well, I think this should happen or that should happen. And so there's been plenty of times when I felt like the judge didn't follow the law, but they were within their rights, within the rules of discretion, to decide that they wanted to rule a different way, even though I felt like, that's outrageous. But within discretion, it's not. And then when you try to appeal those decisions, they're very difficult because the appellate court will give the trial court complete autonomy when it comes to exercising discretion. The appellate court's not going to second guess.
In fact, the appellate court looks for ways to substantiate what the trial court did, if possible.
Yeah, and the only way that they can overturn it is if it was an abuse of discretion, which is a very difficult standard to meet, and the appellate court doesn't want to meet it. What the appellate court wants to do is affirm trial court decisions, because otherwise everybody would want a second trial, and that's not the way the system works. So there's tons of examples I could give where I felt like a judge, didn't do the right thing or follow the law or whatever you want to.
You disagreed with the judge's determination.
Yeah, completely. But within the world of discretion, judges can do that. And that's what you have to understand. And that's why it's so difficult to, prevail on a case in the probate court system, whether it's a trust case or whatever it is that our job as lawyers is not just to lay out the black and white law. AI could do that. Our job as lawyers is to persuade a judge that we're right for the right reasons, because when a judge is exercising discretion, they want to feel good about their decision. we all do, right? We all want to make decisions we feel good about. And so they're not going to make a decision that they don't feel good about. And that's where the persuasive power of the law and persuasive power of a good lawyer comes into play. And that's really what separates, the wheat from the chaff, or whatever the saying is. The good lawyers from the great lawyers is the ability to persuade a judge in that fashion. And it's not easy, and it's not as easy as you think it is. And it's not a matter of just saying, well, I've got the law on my side and I'm the person who's right, and so the judge is going to rule for me. Well, I mean, you think you're right, but a judge may not see it that way, and a judge is viewing it from a different perspective with different life experiences too, and keep that in mind. And so if you're exercising your discretion or being asked to make a decision, you're coming at that decision with your life experience, which could be very different from your life experience. And so the way you're going to view things is going to change. So it's a tricky thing, and I don't think people fully understand that.
Yep.
Sharon followed up with her question about having 3 different versions of formal accounting. She says the real property and liquid money was worth over 1.5 million, and he, the trustee, gave me 72,000. He withheld all money because I wouldn't indemnify him for all actions. I still have not signed anything. Well, that might not be a question here, and I don't know if we can call this legal advice. I don't think we can, but maybe what guidance or what options does Sharon maybe have here?
Yeah, my feeling is the same that Keith and I talked about earlier, and that is, it sounds like this person, Sharon, needs to seek the advice of competent counsel and figure out what's going on here. And kudos to Sharon for not signing anything without first getting the advice of legal counsel. I can tell you this without giving legal advice, Sharon, and that is, you're not required to sign any indemnification agreement to get your rightful inheritance. And so if a trustee if that's the standard they're using, the rule they're using, they're incorrect, they're wrong, and they may need a judge to explain to them that's not how this works.
Or release.
Yes.
You also, the trustee can't demand that you sign a release of liability to get your distribution.
Yeah, see, trustees can't be in conflict with the beneficiaries, and indemnification automatically is a conflict because they're asking you to give up some of your rights to their benefit to protect their own hindside, and that is inappropriate. It shouldn't be allowed. And so it sounds like, Sharon, what you need to do is you need to seek the advice of a competent lawyer, and I'm sorry to hear what you're going through.
And continue to not sign stuff until you
unless
do.
A lawyer reviews it.
Right.
That's right.
Yeah, and don't even get us started on how much we hate indemnification clauses. I mean, just generally speaking, they're horrible. And it's funny how often people throw them around. It's like they're the biggest, riskiest things you could ever sign.
Yes.
You don't know what you're getting yourself into. So anyway, that's a whole nother episode, but beware of indemnification clauses for sure.
Okay, we had one last talking point. We were talking about attorney and client relationships and things like that. And we want to pose this question to you too. When a client and attorney are meeting, what questions do you ask them, and what do you look for in a good match?
Ooh, boy. Well, I mean, I think that there needs to be a connection of what the overall goals are for the case, and understand you want the lawyer and the client to be on the same page with what goals you're going to accomplish. And I think where people get into trouble is when the client thinks, I want to do this, and the lawyer thinks, I want to do that for you, and they're not on the same page. And then as that representation continues, the client's going to continually look to issues that they want addressed, and the lawyer is going to keep saying, those are irrelevant. I don't want to do that. So I think if you can define up front, what are the goals of this case? And, lawyer, do you think you can accomplish those goals? Are those goals you want to, try to accomplish? And client, are you okay with those goals? And are you okay with maybe not going after other goals that you think are important, but this lawyer's telling you, is not worth the time, money, effort, whatever? And if you don't feel comfortable with that as a client, then don't choose that lawyer. Talk to a few other lawyers and see if somebody else has a different view. But if you talk to 2 or 3 different lawyers and they're all telling you that whatever issues you think are important aren't, then, maybe they're right. So maybe you have to kind of compromise and give up on that. But I think the biggest issue is when the lawyer and client are not aligned. I think that causes a lot of problems moving forward. Would you agree?
I do agree. When I think about the relationship between us and our clients and vice versa, I think that probably 90% of our relationships are quite good, and they are mutually beneficial, and there's even admiration on both sides after the case is over. There is a subset of clients that I don't think are conducive to good outcomes in cases. And one of those would be the Googler, the person who Googles everything,
right,
and questions everything I do, or puts my stuff into Chat GPT and grades my petition, grades the complaint or the lawsuit.
Right.
And Chat GPT said, you didn't do a very good job on this, or whatever the case may be. That's not going to work real well going forward. And then the lawyer that the client that just wants the cheapest lawyer they can get. They don't care about the quality, or at least they don't, maybe they do care about quality, but they ultimately only care about how much they pay, which, by the way, that's important. It's important for lawyers and clients to discuss how much this is going to cost, but it should be a reasonable conversation between both, and there has to be an understanding of why something costs X, Y, and Z. I don't think most people understand why legal fees are so high. It is very expensive to run a law practice. I can say that. It's very expensive to litigate a case.
It's very time consuming.
And it has nothing to do with our car payments or our homes or our lifestyles. We certainly get paid for what we do. We're not working at McDonald's or something like that. But, so that's the other one. And then the other one that comes up from time to time is the client that simply wants a junkyard dog. And they want you just to go and draw blood, bite the other side, and cause problems for them. Well, that's not what we do. Okay,
right.
Now we know how to fight. We know how to battle within the bounds of the Code of Civil Procedure. We know how to push a case forward. We know how to even get a trial date and get a judge or a jury to hear your complaint to hopefully hold the other side accountable. But we're not here to be junkyard dogs. We're not here to do things that are unethical. We're not here to embarrass the other lawyer. We're not here to fight with the other lawyer just for fighting purpose, just for no other reason. And so, again, this is not the majority of clients. But when I see those clients come along, I say, gosh, you know what? You might be better off with another law firm.
Yeah, because you, as lawyers, what we want to do is achieve a result. We want to get a good result for you. We don't want to harass people just for the sake of harassing you. We're not, bouncers at a bar or something. So I think there is a distinction there. But yeah, I think those are really excellent points. And I don't think people understand the complexities of litigating. It's very time consuming. It's very complex. And it's hard to see because we don't produce a product that you can pick up and hold and look at. But it does take a lot of time. And there's a difference, to your point, there's a difference between quality versus, value. So if you're a value shopper, you're looking for the cheapest one. If you're a quality shopper, you're looking for the best quality. And you do want quality that isn't, overly expensive. But still, if you want quality, it's going to be more expensive. It's not going to be the cheapest one. So kind of decide up front as a client, what are you looking for? Are you looking for quality, or are you just shopping on value? Those are going to be two different lawyers and two different law firms entirely.
If I needed a heart surgeon or a brain surgeon, which side of the spectrum?
Yeah, I'm going to go for quality,
okay.
I think. Yeah, when it comes to litigators and heart surgeons, and, I tend to err on the side of quality. And if I'm just, looking for tomatoes, it's probably value, right? That's the cheapest tomato.
We got a really, really nice response back from Sharon thanking us. And Sharon, best of luck to you. I hope that everything works out for you.
Totally. And maybe one last question. Maybe we can end on this, but I want people to know, what practice areas you guys are strong with, have experience with, or deal with. And Jennifer writes in again and asks, do you have any experience with common law trusts?
Well, in California, we don't really have a common law trust. I'm not sure what that would be referring to. We have revocable trusts. There's all sorts of different types of trusts that are created. There is in California something called an oral trust, which is ridiculous. Like, don't ever try to do it. You're out of your mind. Where if I give my property to you and I say, hey, I want you to hold this in trust for me, but we don't have anything in writing, in theory, that's enforceable. In practice, you're an idiot and should not be doing that. So yeah, I don't really know what you refer to as common law trust, at least here in California. What was the other part of the question, though? I'm getting too old.
That was all.
Just what practice areas do we handle?
Oh, practice areas that we handle. Yeah, I mean, primarily we're doing trust and will litigation. So we're, the biggest one is if somebody's disinherited, we're going to fight to get them back into the estate or trust. And then the other big one that we deal with a lot is where somebody's entitled to something out of the trust and they're not getting it. The trustee's bad. They're not making distributions. They're trying to hide money. They're not accounting properly. And then we also get into trusts that are supposed to be held in trust for some term of years, and we're able to get in there and actually terminate them early. And so we call those, just in our law firm, we call those trust busting cases, but we've been handling a lot of those, and we always have handled a lot of those. So that's kind of where we specialize in, is anything that's a problem when it comes to trusts and wills.
Yep. And again, these always make me happy when I see these. I see C. Kearney said, thank you for our comprehensive answer. And so C. Kearney, we wish you the best. We hope that that was helpful and at least get you headed in the right direction. And Keith, I really enjoy when people ask these questions, and I hope that we understand them as you send them to us. And we're always happy to give you our 2 cents, understanding that we're not giving you legal advice, but we do want to point you in the right direction and help you out in that regard.
Yeah, absolutely. So keep asking the questions. You can put questions in the comments below of this video. Even after we go off live, these videos stay on our YouTube channel. Type in a question in the comments. We do review them. We do answer them on the next Ask Two Lawyers. And we're always happy to, give you our 2 cents for what it's worth.
And I think, aren't we going to try? I know that our schedules are crazy, and producer Eric, I feel so bad for him because he's always chasing us around, trying to get us on
herding
video.
cats.
Yeah.
Yeah.
But we're going to try to do this at a regular time on Fridays so that people can count on us being here at the same time, same bat channel.
Yeah, right. Yeah, exactly.
And that way that, more people can ask questions and get them answered.
Yeah. And we're going to try and, it's Friday, 1 o'clock. We're going to try to make that a solid time, but you're going to have to bear with us because, with lawyers, things come up, and what are you going to do? But yeah, that's our hope. Like I said, always feel free to ask any questions in the comments in this video or any of our other videos. We always get the comments in all of our other videos. We have a very large video catalog on our YouTube channel on all of these topics that we cover. You're welcome to look any of those up. As always, make sure you subscribe so you can get notification of when we go live, and you can like our videos because that really helps other people find them as well. And we appreciate you joining us on this Friday afternoon, and we look forward to seeing you at the next Ask Two Lawyers.
We'll see you next week.